Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie LeBenz. Today we're going to talk about settlement in context of a child custody establishment case. What we're looking at here is that a petition to establish legal decision-making, parenting time, and child support, possibly also paternity, has been filed. It's been served on the other party, and maybe you've gone through disclosure, maybe you've done some discovery, and you have all of the information you need, and now you're ready to negotiate. We talked about in previous videos about how you could seek to negotiate before filing. You could seek to negotiate right after filing. And this is some of the same concepts, just looking at some of the options that are available if the case is a bit more developed and you've gone through some of the other steps in your case. So let's first, just to make sure we're on the same page, let's look at, what exactly is on the table to be settled in the context of a child custody establishment case. Well, number one would be legal decision making, and that can be sole or joint. Of course, there can be joint with final decision making on certain issues to one parent. There can be joint on some issues, sole on others. So there's different ways to craft a legal decision-making agreement. But the bottom line is that if you're going to resolve legal decision-making, you need to decide if one parent is going to have sole decision-making or if the parents are going to share joint decision-making on the issues of education, healthcare, personal care decisions, and religious training related to your children. Whoa. Don't go backwards, go forwards. Here we go. Parenting plan. You'll need to resolve the year-long parenting schedule of exactly when the children will be with each parent. So the date of the exchange, the time, the location, who's doing pickup, who's doing drop-off, and then any other agreements, any other terms of your plan. For example, at what time one parent who doesn't have parenting time can contact the children to have a phone call or something like that. And how long is the phone call and how does it take place? All of the terms about parenting, extracurriculars, the schedule, holidays, during school year, during summer break, all of that would be in the parenting plan. And then there's child support. So number one is figuring out what is the amount of child support. Number two, who's going to be responsible for providing medical insurance coverage for the minor children? And then for those medical expenses for the children that are not covered by insurance, how are you going to divide those between the parents? Is it 50-50, 60-40, 70-30? What is the division of any uncovered medical expenses? And then for the child tax exemptions, how are you dividing those between the parents every year? If either party has made a request for legal fees and costs, then that would be a final issue to resolve in negotiations as well. What are your options for trying to settle your case? Well, number one, you can try negotiations between you and your co-parent, or if they have an attorney, you could seek to negotiate with their lawyer. A resolution management conference. We'll talk more about that in today's presentation, but that is an opportunity to exchange positions with the other side and try to negotiate a resolution. You can request mediation. It could be a private mediation or through the court, because the court does provide mediators as well. And then you can also request a judicial settlement conference. I'm not sure how available judges are in like Maricopa County for judicial settlement conference. I think Billy had mentioned to me that they have some separate judges that just handle these. So maybe it is something that's granted quite often, but I know up in Yavapai County and in many of the rural counties, these judicial settlement conferences are easy to obtain. If you request it, it gets granted and it can get set. So it's a great option too. It's essentially where the judge, or either the judge assigned to your case or another judge, will essentially act as a mediator and work with the parties to try to resolve the case. All right, let's dive a bit deeper into this settlement option, which are direct negotiations between the parties. Of course, if the other side is negotiated is represented by a lawyer, then you could negotiate with their lawyer. A great way to initiate a settlement negotiation is to make a written settlement offer. And within that offer, include a deadline. When does the offer expire? You know, what's the last day they have to accept or reject this offer? Negotiate. You make the settlement offer, and then you can enter into negotiations about it. In other words, if they say, I reject your offer, well, okay, well, what parts of it specifically did you not like? You know, let's talk about legal decision making. What about legal decision making are you disagreeing to? Let's talk about parenting time. What about my proposed parenting plan are you objecting to? Let's talk about child support and go through all the issues and, you know, delineate what exactly is in dispute, and then look at that list. And are there any points to compromise on? Are there any points where maybe you can meet in the middle and get a resolution in place? And so that's where you can negotiate. And let's say you are able to reach an agreement. Okay, so you decide to share joint legal decision making. You decide to share essentially equal parenting time and put together a parenting plan that explains your week on, week off parenting plan and what happens in the summer and what happens for the holidays. And then you work out a child support worksheet, and it shows that there's 0 child support owed because you have equal parenting time and you have relatively equal incomes. And you have an agreement. Okay, you decide who's going to cover medical insurance for your children. You decide the percentage division. You're going to do 50-50 for uncovered medical. And then you're going to equally divide the child tax exemptions. All right, so you've got a full agreement. And at that point, you want to take the terms of your agreement and put it into a stipulated order to establish, also known as a consent judgment and order for legal decision-making, parenting time, and child support. So you want to put the agreement into a proposed order that's then going to get filed with the court so the court can sign off on it and formalize your agreement and make it a formal order of the court. Now, if you reach an agreement, okay, so we talked about how to negotiate up to that point, put the terms of your agreement into the consent judgment, parenting plan, child support worksheet, child support order, and income withholding order. And we're going to go over all those forms. And then both parents need to sign the papers before a notary or court clerk. And then you file the signed documents with the court. And once the judge signs it and files it with the court, your case is resolved. Let's look at the consent judgment and order for legal decision-making, parenting time, and child support. This is the Maricopa County form. So this is where you reach an agreement because it's a consent, it's judgment by consent. So that's an agreement. And it covers legal decision-making, parenting time, and child support. And if your case involves paternity, you can, check these boxes as well. So fill out your caption, move on to page 2, list the names of your children, their dates of birth, where they were born, information about the parenting class, child support, indicate child support has been determined by the guidelines, or if you're seeking to deviate, that would be this subsection B and the associated boxes. If you're going with the guideline amount, that would be box A. This is court-approved discretionary parenting time adjustment and other adjustments. This is adjustments to the child support amount, ability to pay, indicating that one party does have the ability to pay the amount of child support. Let's see, we've got a question here. Without children, is there any issue with language? Can I negotiate that instead of his attorney? Or can I email him my settlement proposal, or both? I wanted to send it in Spanish so my husband knows what I'm talking about. I don't believe it's attorney is fair and is not explaining it. It's not worth to spend. It's fighting over. Technically, if the other side is represented by an attorney, the offer should go to the attorney. That's technically the proper way to do things. You can, and we'll go through in this presentation, various settlement options. And there is an option for mediation between the two of you where attorneys aren't present. So maybe that would be a way to get, his direct attention to try to resolve it. But yes, if the other side is represented by an attorney, you should go through the attorney. Now, oftentimes in practice, in a divorce, spouses will end up talking to each other and working things out, be it at a parenting exchange or they're at the house dividing property and they decide to work out additional issues. So it's certainly not unheard of for spouses to end up communicating through the course of dividing their lives and negotiating. But if you're going to write out a letter and make an offer, it would make the most sense. You'd want to do that through the lawyer because it could be problematic if you don't. Okay, so I think we covered this child support page. The next page, it's about domestic violence or alcohol or drug convictions. If there's supervised or no parenting time being requested. And then we get into the court orders part. So you would fill this part out too. If paternity is at issue, fill out this part, indicate primary residence, parenting time, legal decision-making, child support, division, or the medical, dental, vision care insurance coverage, and then the division of uncovered expenses for the minor children. If there's any past medical expenses that have accrued, that also can be included if that's part of your agreement. Any other costs, you're going to exchange financial information every 2 years, every 24 months. It's part of the standard orders. If there's anything else you want the court to order, you could fill it in here. You'd leave this part blank. That's where the judge would date and sign if the judge accepted and approved of your agreement. But here is where each party would sign. So party A, party B, notarized. If the Attorney General's office, the child support office is involved, they would sign here approving the agreement. So that is the consent judgment and order. And then a companion to that is this parenting plan, because as you saw, this part with the parenting time is very small. There's not a lot of room here. And so here we have reasonable parenting time rights as described in the parenting plan attached as Exhibit A. So if you'd like, you can check this box and then attach this parenting plan agreement as your Exhibit A. And this is much more detailed. So obviously fill out your caption, indicate if you're joint decision-making or sole, the minor children involved, sole decision-making, joint, indicate all the terms of your agreement, the physical custody and parenting time during the school year, during the summer, travel, holidays, 3-day weekends, phone contact, educational arrangements, medical and dental arrangements, religious education, other arrangements and comments. So check all the boxes for what you've agreed to will apply as part of your parenting plan. And then you both sign. You also sign here that the sex offender notice. And then for joint legal decision-making, you fill out the domestic violence and drug convictions questions, and then some additional questions here. How often will you review it? Signatures, notaries. So that's the parenting plan. And then, so we've got that as Exhibit A, and then Exhibit B would be your child support worksheet, which this is a blank one. It would be filled out with your information, and this would be whatever your agreement is for child support. So whatever you agree to should be reflected in this worksheet. If you are agreeing to an amount other than what's in the worksheet, then you would need to include the deviation language. You need to fill out those boxes. Let me go back So this is the parenting plan. We're going back to the consent judgment and order. Child support. This is the adjustment. So this is if part A, this is if you're using the amount in the guidelines in the worksheet. This is if you're deviating from that and you have to fill out all of this additional information. Okay, so let's go back to the child support worksheet. All right, so this would be Exhibit B, reflecting either what the guideline amount is, and then you can have your deviation language, or what the guideline amount is and showing that's what you want the court to order. And then there's the proposed child support order. This is a blank one. This child support order will auto populate and auto generate as part of the Excel spreadsheet Arizona child support calculator, which is, one of the documents attached below so you can access it. You'll find the child support order tab at the bottom of the Excel spreadsheet. When you fill out the worksheet part first, that's where you get all the information that'll auto populate within this order. But this obviously is from Yavapai County. If you fill out the worksheet for Maricopa or any other county, that's what'll populate here. The names of the parties, your case number, your atlas number, if you have one. And then the names of your children, the child support amount, all of this stuff will be filled in. And so you'll just want to review it and make sure it accurately reflects your agreement. And then you leave this blank and the judge will sign it. Finally, there's the current employer information form. So this form is to be completed for an income withholding order, an order to stop an income withholding order, or a notice of a change of employer. So this is for Maricopa County, and this is the information to provide so that, for example, an income withholding order can be issued. So what is an income withholding order? If child support is ordered, then an order called an income withholding order is also issued, and it goes to the employer of the person that's ordered to pay child support. And it orders that employer to deduct from the obligor's paycheck the amount of child support that's owed and transmit that to the child support clearinghouse to then go to the parent that's owed the child support. So that's what an income withholding order is. And this is the information needed. So this is the form that Maricopa County wants you to fill out. But I also wanted to show you the Yavapai County income withholding order, because many counties will use this form and want you to fill it out. And so this is where you're just going to start going through the lines and fill it out the best you can. And you'll see, I don't know, you'll just go through the whole form. It's 5 pages and fill it out. And that's the income withholding order that's sent to the employer to start withholding the child support from the paychecks and send it to the child support clearinghouse. So just as a review, if you reach an agreement, you want to put your agreement into the consent judgment, parenting plan, child support worksheet, and income withholding order. Both parents sign the documents before a notary or court clerk. And then you file the completed signed consent judgment and associated documents with the court. When the judge signs and enters the consent judgment and associated documents, your case is resolved. Now, I want to make a little distinction here. If you reach an agreement to 0 child support, or the child support worksheet produces 0 child support order, you don't need to do the income withholding order. All right. If there's no child support to be paid, then nobody's employer needs to be ordered to withhold money from their paycheck. So I just want to make that distinction. You won't need that form if it's a 0 child support amount. Okay. All right, now let's talk about the Resolution Management Conference. What is a Resolution Management Conference? This is an opportunity for the court in a somewhat informal way to meet with both parties to try to resolve as many issues as possible. So this is the court's opportunity to manage the potential resolution of the case. In general, the petition to establish custody will be filed. It'll get served. The responding party will file a response. In general, the court will schedule a resolution management conference about 40 days after the response is filed. So these automatically get set by the case, or excuse me, by the court once the case is past the response has been filed stage. In preparing for a resolution management conference, both parties are required to file a proposed resolution statement 3 to 5 days prior to the resolution management conference. Look at your order that set the resolution management conference to see what your deadline is. If the parties reach any agreements, their agreements can be put on the record in a Rule 69 agreement at the resolution management conference and made into a formal order of the court. So keep that in mind. Let's say you reach an agreement to share joint legal decision-making, but you're still figuring out parenting time. At the RMC, the court could make your agreement to share joint legal decision-making a formal order of the court through what's called a Rule 69 agreement. We'll talk about that more in a minute. Let's look at the proposed resolution statement. This is the proposed paternity and legal decision-making resolution statement. So you just fill this out with everything that applies in your case: legal decision-making, child support, parenting time, attorney's fees, name change, any other issues, settlement. You'll sign. This is your mailing certificate showing that you provided a copy to the other side. And then let's talk about the Rule 69 agreement. So, and just a final point on the resolution management statement. So you'll fill it out, you'll file it with the court, and then you'll mail a copy to the other side. Prior to the resolution management conference, you're supposed to do what's called a meet and confer with the opposing party or their attorney. And that's supposed to take place usually 5 days before. And that'll be 5 business days before the resolution management conference. So you're supposed to have a phone call or meet in person and try to resolve as many issues as possible. If you reach any agreements and the court wants to make them a formal agreement at the resolution management conference, the court can do that through what's called a Rule 69 agreement. So this is Rule 69 of the Arizona Rules of Family Law Procedure. And it says that an agreement between the parties is valid and binding if the agreement is in writing and signed by the parties, the agreement's terms are stated on the record, or the agreement's terms are stated in an audio recording made before a mediator or a settlement conference officer appointed by the court. An agreement under this rule is not binding on the court until it is submitted to and approved by the court. And then if you want to challenge the agreement, you have the burden to prove the defect in the agreement. So if you enter into a Rule 69 agreement and later on you want out of it, you bear the burden of proof, and it's nearly impossible to get out of them. All right, next let's talk about the option of mediation. So this is under Rule 67.3, and you can do private mediation or mediation through the court, but overall participation in mediation is voluntary. Everything that's said or any written communications related to the mediation, it's all confidential. The mediator must not communicate with the judge about anything that was said, submitted, or done before or during the mediation, except basically to tell the judge what the ultimate outcome was, tell the court if somebody didn't appear. So there's limited information the mediator can give the judge. The parties may privately mediate any issue and dispute. The parties may agree to and jointly select a private mediator. The parties must sign and file a notice that states that private mediation will take place, the name of the mediator, and specifying the date set for the conference. The parties may ask the court to select a mediator for them. The parties must contract directly with a private mediator and pay the fees. The presumption is that the cost of mediation will be equally shared by the parties. On the agreement of the parties, the court may enter an order referring the matter to mediation, or the court can decline to refer a matter to mediation if it appears that mediation is inappropriate because of parental unfitness, substance abuse, mental capacity, domestic violence, or other good cause, or because mediation will cause undue delay. So if one parent is requesting mediation and you don't want to do it because of a history of domestic violence or other issues, look to see, can you make an objection? This is what the court's going to look at: parental unfitness, substance abuse, mental capacity, domestic violence, or other good cause. So if you're objecting to mediation, you'd want to look at phrasing your objections in one of these, under one of these categories. I have an upcoming RMC. Can I request private mediation? How much is it? You can, and we'll go through some ways to request private mediation. There's also court-ordered mediation that generally only covers legal decision-making and parenting time disputes. In Yavapai County, you can use the court-appointed mediators and address issues outside of legal decision-making and parenting time, and it costs $400 for up to 4 hours with the mediator. And usually the parties equally divide that cost. So what you could do at your RMC is ask the judge, I'd like to do mediation. What are our options, as far as what the court can provide? But generally the court has a free mediation program for legal decision-making and parenting time at the very least. So the court will consider domestic violence, try to make sure that the victim is protected from harm, harassment, or intimidation in the context of mediation. The court is supposed to notify the parties in writing or orally that they have the right to ask to waive mediation. And the mediator must decline to mediate or terminate mediation if domestic violence makes mediation inappropriate. A party may not file to apply for default if the parties are doing mediation. You have to wait till the mediation's over to apply for default. After the court has entered an order or referral to mediation, the mediator will schedule joint or individual conferences. So the court can refer the matter to the court's mediation department, and then the mediator will schedule joint or individual conferences with the parties, and each party must attend conferences as the mediator directs. The mediator may permit other persons other than parties and their counsel to attend or participate in mediation if those other persons agree in writing to be bound by the confidentiality rules. An attorney for a party may be excluded from a private mediation conference only if the party and counsel agree. However, a conciliation court mediator or conciliation court policy may authorize the exclusion of counsel. So I know, at least in Yavapai County, generally attorneys won't go to the mediation. If they do go, they need to file a notice that they're going to appear by a certain deadline. So often attorneys don't go, just let the parties try to work it out with the mediator. But if an attorney is going to go, they usually have to give notice. If a party fails to appear, the judge can be notified and institute sanctions. And then the court will not continue a scheduled trial or hearing based on a failure to complete mediation unless good cause is shown. Okay, and then we've got the mediation statement. This is optional. The mediator may require the parties to submit a mediation statement before the conference. And if the mediation statement is requested by the mediator, then it's just submitted to the mediator. It's not filed with the court. And then the mediation statement would contain a general description of the issues in dispute, the party's position on each issue, and evidence to support their position, their current affidavit of financial information, a list of outstanding debts, if there are any. Some of this is for divorce. So if we're looking at child custody, an affidavit of financial information would be helpful as far as child support. And then if you were looking to get contribution for any past medical expenses related to the children, you can include that type of information. A summary of the negotiations you've had thus far, and any other information you think would be helpful. So that would need to be those A through D That's what needs to be in the mediation statement if one is requested by the mediator. And then it only goes to the mediator. It's not filed with the court. If you reach an agreement in mediation, it will become a binding agreement by either being put into writing or being put on the record. And as part of that, there needs to be an acknowledgement that the parties are entering into the agreement voluntarily. They intend the agreement to be final and binding. They believe the agreement is fair and equitable. If they have minor children, they agree that the agreement is in the best interest of the children. And then if an agreement is reached, the parties must provide notice not later than 10 days after the mediation. And if they haven't resolved everything, then they need to provide the court with notice of anything that remains unresolved. And the mediator usually does that as well. The mediator generally will provide the notice to the court. For all family law cases, this is under Rule 68 that involve a dispute over legal decision-making or parenting time. They're subject to mediation. So the court must determine whether mediation or ADR services are appropriate in a particular case, and they can deem it to be inappropriate. But for the most part, they're wanting every case to at least try mediation if the parties have disputed issues. If there's a disagreement between the parties concerning legal decision-making or parenting time, either or both parties may file a motion or request for mediation or ADR services. An order for mediation or ADR may also be made on the court's own motion. Any agreements reached as a result of mediation must be in writing. The parties must sign the agreement, and their attorneys, if any, must sign or object to the agreement within 30 days after the mediation. The court retains final authority to accept, modify, or reject the agreement, or to set a further hearing. Any agreement that is reached and approved by the court is binding. So here's the form to request mediation. Here's the form for a joint request. If you and your co-parent agree you want to try mediation. And then here's the order referring your case to mediation. All right, let's talk about this final settlement option, which is a judicial settlement conference. This is under Rule 67.4. On a party's motion or on its own, the court may order the parties to attend a settlement conference. If the parties agree, the assigned judge or commissioner may conduct the settlement conference. So at the settlement conference, the judge meets privately with each party. And in general, that's not allowed under the rules because you're not allowed to have ex parte communication with the judge. So this is saying the parties are agreeing, yes, we agree that this judge can engage in ex parte communication with us in the context of this settlement conference. So the parties would agree to either have the judge assigned to their case play that role, or they could have a different judge. Now, I believe in Maricopa County, it's generally a different judge that's assigned, but in the rural counties, there'll be a question, are you going to have the judge assigned to your case handle it or ask a different judge? And it's really just a strategic decision. Some people like using the judge assigned to the case because they get to see what the judge really thinks about the case behind the scenes. Other people say, oh, I don't want the judge having so much inside information because I think we're going to go to trial. So it really just depends. The court may order the parties, their attorneys, and any other person who the court deems necessary to facilitate settlement of the issues to attend and participate in the settlement conference. The court may enter an order setting the date for the conference. The judge may require each party to submit a settlement memorandum before a conference. It doesn't get filed with the court. It just goes to the judge, so the judge's assistant. And it's the same stuff that was in the mediation memo that we talked about. The same stuff would go into the settlement memo. It's the issues in dispute, your issue or your position on each issue, any evidence in support of your position, your AFI, any outstanding debts you're wanting reimbursement for, a summary of the negotiations you've had thus far, and any other information you think would be helpful to the court. If the court determines that it will facilitate settlement, With the consent of both parties, the court may communicate with one party during the conference outside the presence of the other. So that's that ex parte communication we talked about. If there's been domestic violence, the court must put reasonable procedures in place to protect the victim. Any agreements that are reached can be made binding agreements through a Rule 69 agreement, in which the parties acknowledge that they're entering into the agreement voluntarily, that they intend the agreement to be final and binding. They believe the agreement is fair and equitable, and that the agreement is in the best interest of their children. All right, so an agreement between the parties is valid and binding if the agreement is in writing and signed by the parties personally or by counsel, the agreement's terms are stated on the record, or the agreement's terms are stated in an audio recording made before a mediator or settlement conference officer appointed by the court. An agreement under this rule is not binding on the court until it is submitted to and approved by the court as provided by law. And then if you're going to challenge a Rule 69 agreement reached at a judicial settlement conference, you would need to show the defect in the agreement. Okay, let's look at a motion to set a judicial settlement conference. So I created this form. I didn't find one in the set forms. So fill out all the parts in red so that they match up with your case. And then fill out your mailing certificate. And then also here's the proposed order setting judicial settlement conference. So again, fill out the parts in red. And then here's a sample memorandum. So here's the general description of the issues in dispute, your position. So I listed the potential issues that could be in dispute. And then this is where you'd list your position and any evidence in support of your position, your AFI, your proposed child support worksheet, summary of the negotiations, any other information you believe would be helpful. So that's an example of the memorandum that could be used for mediation or a judicial settlement conference. Okay, we've reached the end of our slides. Just as a summary, here are your settlement options. You can engage in negotiations with your co-parent or their attorney. You can seek to reach agreements through the course of the resolution management conference, either in the meet and confer ahead of time or at the conference itself. If you reach an agreement at the conference, you can put that into a Rule 69 agreement on the record and then put it into writing. If your negotiations result in an agreement, you could put that into the consent judgment and order. Mediation is another option, and then the judicial settlement conference. Okay, I hope that was helpful. If you have any questions, please bring those to the Q&A. Thank you.